It's fascinating, isn't it, to consider how different societies throughout history have grappled with the fundamental concept of justice. What at times means times to be fair, to be right, to punish wrongdoing, and to uphold order. We often look at ancient civilizations and project our modern ideas onto them, assuming a certain linear progression of legal thought. But what if I told you that some of the most intricate, profoundly philosophical, and even shockingly pragmatic systems of justice existed thousands of years ago, in a place we often misunderstand? What if I told you that in ancient China, justice wasn't just a single monolithic entity, but a layered, multifaceted construct? A system so deeply interwoven with their philosophy, their society, and their very understanding of the cosmos, that it operated on no less than 4 times distinct levels? These weren't just different courts, mind you. They were entirely different times of seeking resolution, each with its own guiding principles, its own authority, and its own unique approach to what we might call truth. And the most astonishing part, you wouldn't believe some of these levels, even times, existed. Times in a centralized imperial state, let alone how deeply they influence the daily lives of millions. Think about it for a moment. In a society that valued harmony above almost all else, how did they balance the need for strict laws with the desire for moral cultivation? How did they ensure accountability from the humblest farmer to the highest official in a hierarchical system? The answers lie within these 4 levels. They reveal a legal landscape far more nuanced than simple penal codes or imperial edicts. A world where family, community, philosophy, and state power all converged to define what was just. We're going to peel back the layers of time, venturing into ancient China, a civilization that, for over 2 millennia, developed a legal system that was distinct from the common law and civil law traditions of the West. It was a system that drew deeply from 2 powerful, often competing, philosophical schools: the strict, order-driven tenets of legalism and the benevolent, morally focused doctrines of Confucianism. This interplay, this constant push and pull between rule by strict law and rule by moral example, is key to understanding everything we're about to explore. Now, when most people think of ancient Chinese law, they often conjure images of harsh punishments, strict imperial decrees, and perhaps a somewhat rigid authoritarian system. And yes, elements of that were certainly present. The legalists, for example, believed human nature was inherently selfish, and that strict, codified laws, coupled with severe punishments, were the most effective way to maintain social order. They were instrumental in establishing the first unified imperial legal codes, particularly during the Qin dynasty, which was notorious for its harsh enforcement. But then you have Confucianism, which emphasized virtue, moral education, and the cultivation of proper social relationships. Confucius himself believed that if people were guided by virtue, they would develop a sense of shame and become good, far more effectively than if they were simply led by edicts and threats of punishment. So, how did these 2 seemingly opposing philosophies coexist and shape the very fabric of justice? That, my friends, is where our 4 levels come into play. They represent a dynamic, sometimes contradictory, but always deeply considered approach to maintaining social order in one of the world's most enduring civilizations. Our journey begins at the very grassroots, in the heart of the community, where most disputes actually started and, ideally, ended. This brings us to what I consider the first and perhaps most foundational level of justice in ancient China. Justice by family and clan. In a society built upon patriarchal structures and an intricate web of kinship, the family, and by extension, the clan, was the fundamental unit of social order. Filial piety, or times xiao*, was not just a moral virtue. It was a societal cornerstone, deeply ingrained in law and custom. Disputes, particularly minor ones, were almost always handled internally, long before any state official even heard a whisper of them. Think of it. If a disagreement arose between neighbors, or a minor transgression occurred within a village, the first recourse wasn't to run to a magistrate. No, that would often be seen as a failure of the community itself. Instead, elders, respected family patriarchs, or even village leaders would step in. Their authority wasn't granted by imperial decree, but by moral standing, wisdom, and the collective respect of their community. Their goal wasn't merely to apply a rigid legal code, but to restore harmony, preserve faith, and ensure that relationships, familial or communal, remained intact. Mediation was paramount, and reconciliation was the desired outcome. This was justice rooted in time's Legalist, in ritual propriety and moral suasion, rather than time's Fa***, strict law and punishment. It was about understanding the specific circumstances, the moral background of the parties involved, and making judgments based on Confucian standards of benevolence and righteousness. Imagine a dispute over land boundaries between two families, or a minor theft within a village. These wouldn't necessarily be seen as criminal matters demanding state intervention right away. Instead, the focus would be on restoring equilibrium. Perhaps a public apology, a restitution of goods, or a symbolic gesture of reconciliation would be deemed sufficient. The pressure to conform, to avoid bringing shame upon one's family or clan, was immense. Community reputation, after all, was everything. In some dynasties, like the Ming, villages even had their own conventions and regulations, interpreted by village leaders, sometimes even featuring declaration pavilions, where names of those who committed mistakes, like being unfilial, would be inscribed as a warning. Once the mistake was corrected, the name would be removed. This was a powerful social rather than strictly legal mechanism. This system, however, wasn't without its flaws. While it fostered tight-knit communities and emphasized moral accountability, it could also be deeply hierarchical and potentially biased. The social status and wealth of a family could undeniably influence judgments. If you were from a powerful clan, your position might offer you a degree of protection or leniency that wasn't extended to others. Nevertheless, for the vast majority of common people, this was the primary, everyday experience of justice, where local custom and communal morality held sway, aiming to resolve internal conflicts and ensure social stability without the heavy hand of the state. But what happened when these local mechanisms failed? Or when a crime was too severe, too disruptive, to be contained within the village or clan? This leads us to our second level, *** justice, by local magistrate, the county level. ***, when a dispute escalated, or a crime, especially a serious one, demanded official intervention, it moved up the ladder to the county magistrate. This was the lowest rung of the official bureaucracy, but arguably the most crucial in terms of direct governance. The county magistrate was a truly formidable figure, a combination of administrator, tax collector, judge, and even investigator. In Imperial China, judicial affairs were not handled by a separate, independent judiciary. Rather, they were part of the administrative responsibilities of officials at all levels. The magistrates' court, often located within their yamen times or official compound, was the first point of formal state justice. Here, the process was distinctly inquisitorial. Unlike modern adversarial systems where two lawyers argue a case, the magistrate himself was the primary investigator. They would actively examine cases, question witnesses, gather evidence, and even perform tasks that might today fall to forensic specialists. They were, in essence, judge, jury, and lead detective all rolled into one. This system was so central to justice that an entire genre of fiction, known as Gong'an Times or legal fiction, grew out of the exploits of famous judges like Judge Bao and Judge Di. The goal of the magistrate, once a suspect was identified, was often to extract a confession, and, unfortunately, this process often involved torture. In ancient China, a confession was seen as paramount, almost a prerequisite for a conviction. Once a confession was obtained, the case was largely considered solved. The subsequent trial was often a public reading of the crimes and the confession, followed by the magistrate deciding the appropriate punishment based on the established legal codes. These legal codes, refined over centuries from dynasties like the Tang, Song, Ming, and Qing, were meticulous and structured, defining specific crimes and their corresponding penalties. The Tang Code, for instance, was particularly influential, providing a model for later codes. Punishments varied widely. ranging from beatings with light or heavy rods to penal servitude, banishment to distant regions, and for the most severe crimes, death. However, even at this level, Confucian ideals permeated the law. For example, offenses committed by juniors against seniors, like a son against a father, were punished more severely, reinforcing the Confucian emphasis on filial piety and social hierarchy. While the county magistrate handled most minor criminal and civil cases, cases involving the death penalty, or those deemed particularly complex or significant, had to be bumped up to higher officials for review. This inherent hierarchical structure provided the next level of judicial oversight. This brings us to the third level, justice by prefectural and provincial authorities, review and appeals. Ancient China's imperial system was a highly centralized bureaucracy, with judicial power gradually delegated from the central government down to local levels. This meant that every administrative level above the county magistrate had supervisory and, crucially, appellate powers over the lower courts. For important cases, especially those with severe penalties, a system of mandatory review was in place. This wasn't simply an option for the convicted, it was an integral part of the legal process. If a death penalty case, for example, was tried at the county level, the dossier wouldn't just be filed away. It would be meticulously sent up to the prefectural officials for review. These officials would then assign other subordinates, ideally those without any direct interest in the original case, to conduct a thorough re-examination. This process ensured a layer of scrutiny, a check against potential miscarriages of justice or abuses of power by local magistrates. Only upon confirmation of this review would a final judgment be made and then sent back down for execution. Beyond mandatory review, individuals also had the option to initiate appeals. If a party felt they had been wronged by a county magistrate's decision, they could petition the prefectural or provincial authorities for a retrial or a re-evaluation of their case. This appeal system, evolving from a three-level process in the Han and Tang dynasties to a four-level process from the Song to the Qing, allowed for cases to move from the county to the prefecture to the province or circuit, and ultimately to the capital. The provincial governor, or in some dynasties, the Circuit Department of Trial and Punishment, played a significant role in supervising the judicial activities of the prefects and county magistrates within their jurisdiction. They were responsible for ensuring that laws were applied consistently, that procedures were followed, and that the imperial legal codes were upheld across vast territories. This hierarchical control structure was a hallmark of the centralized state, ensuring a degree of unity and stability in the application of law across the empire. However, the further a case moved up this bureaucratic ladder, the more complex and arduous the process could become. Distance, cost, and bureaucratic inertia could all pose significant barriers. And while these higher levels offered a chance for review and appeal, the underlying inquisitorial nature of the system generally remained. The officials at these levels, much like the magistrates, were still administrators first and judges second, their primary loyalty ultimately to the emperor and the stability of the state. Which brings us to the pinnacle of justice in ancient China, the ultimate authority, the final arbiter. Justice by the imperial court. At the very apex of the ancient Chinese judicial system resided the imperial court, a complex network of central government bodies, all ultimately answerable to the emperor himself. This was the domain of the highest-ranking officials, the specialized ministries, and the emperor's personal judgment. From the Sui and Tang dynasties onward, central government judicial bodies included the Court of Judicial Review, the Board of Punishment, known as times Xingbu *, meaning Punishment Department, and the Department of Censors. The Board of Punishment was essentially the Ministry of Justice, overseeing most judicial and penal processes across the empire. They were responsible for drafting, interpreting, and revising legal codes, ensuring their public issuance, and supervising the entire court system, from local county courts to the central judiciary. They handled major criminal cases, especially those involving capital punishment or high-ranking officials, which typically required the emperor's approval. They also managed imperial prisons, enforced punishments, and reviewed appeals from lower courts, striving to create a unified legal process. The Court of Judicial Review acted as a trial organ, particularly for cases involving central government officials and serious common crimes occurring in the capital. Its decisions would be reviewed and concurred by the Board of Punishment, and any capital punishment judgment required the emperor's final approval. This was an absolute rule. Every execution had to be approved by the emperor, although, as with any vast empire, this law wasn't always strictly followed in remote areas. Then there was the censorate, an independent supervisory body. Its officials, known as censors, had the critical role of investigating corruption, malfeasance, and judicial misconduct at all levels of government. They could impeach officials, report on administrative failings, and provide an additional layer of oversight, acting as the eyes and ears of the emperor. Their existence provided a crucial check, though imperfect, on the immense power wielded by administrative officials with judicial functions. Ultimately, the emperor held the supreme judicial power. In theory, all judicial offices were merely consultants, assisting the emperor in rendering the final decision. Petitions, known as times Zuyi times or memorials, were official documents submitted by ministers to the emperor, serving as a means of communication for opinions, reports, appeals, and seeking instructions. These were often persuasive essays, attempting to sway the emperor's judgment. The emperor's decision, often influenced by both legalist principles of maintaining state control and Confucian ideals of benevolent governance, was final. This power allowed for pardons, amnesties, or even deferred punishments, reflecting a blend of strict law and imperial mercy. This imperial court system was designed to ensure centralized authority, legal unity, and the preservation of the dynasty. It was where the most complex legal, political, and moral dilemmas of the empire were, theoretically, resolved. It showcased the ultimate power of the Son of Heaven to define and dispense justice across his vast realm. So, there you have it. The 4 levels of justice in ancient China. The informal but potent *** justice by family and clan ***, the direct and investigative *** justice by local magistrate ***, the layered *** justice by prefectural and provincial authorities *** for review and appeals, and finally, the supreme *** justice by the imperial court ***. This multi-tiered system, with its deep philosophical roots in both legalism and Confucianism, offers a profound insight into ancient Chinese society. It wasn't perfect. No system ever is. It wrestled with inherent contradictions, like the simultaneous emphasis on moral education and harsh punishment, or the tension between local custom and imperial law. Social stratification significantly influenced how laws were applied, with scholars often enjoying a higher legal status and privileges that peasants and merchants did not. Lawyers, as we understand them, didn't exist in the same way, though legal experts advised in civil cases. Yet, what's truly remarkable is the sheer complexity and longevity of this legal tradition. It adapted, evolved, and provided a framework for governance that endured for thousands of years, shaping not only China but also influencing legal systems across East and Southeast Asia. It was a system that understood at its core that justice isn't a single simple concept, but a dynamic, ever-negotiating balance between order and harmony, punishment and virtue, state power and community responsibility. A truly astonishing legacy, wouldn't you agree?